Buongiorno e benvenuti a questo, il quinto della nostra serie di 5 puntate organizzate per dare un update, un aggiornamento alla situazione con riguardo al Brexit. Oggi siamo arrivati alla fine di questa serie e vi metto in attesa di un annuncio che porterà forse un seguito a questa serie che arriverà nell'anno prossimo. Io mi chiamo Stephen Sprague, sono consigliere della Camera di Commercio del British Chamber of Commerce for Italy e sono responsabile del Brexit Committee che abbiamo creato proprio per seguire tutto quello che riguarda il Brexit. Oggi ci concentriamo sulla questione legata al societario e al movimento di persone. Chiaramente uno dei punti fondamentali per il business italiano, ma chiaramente verso l'Inghilterra, ma anche per il business normale. È un punto molto intimo, molto personale, sia per l'azienda che per le persone coinvolte. I nostri ospiti oggi sono Helen Chamberlain, Vice President and Senior Director HR Advisory at Vistra. Helen, good afternoon. Welcome.
Thank you. Good afternoon, everyone.
Sono Bill Cohen, Vice President Advisory at Vistra. Bill, good afternoon.
Good afternoon.
E last but not least, Gino Zabeo, Commercial Director Corporate at Vistra. Gino, buongiorno.
Buongiorno, buon pomeriggio. Good afternoon, everyone.
Prima di invitare i nostri ospiti a intervenire, il nostro aggiornamento. Allora, l'ultima volta ci siamo detti, forse ci saranno delle notizie, forse ci sarà qualcosa di nuovo che ci porterà o ci aiuterà l'avvicinamento della fine del periodo di transizione. Purtroppo c'è pochissimo da dire. A meno di 20 giorni dalla fine dell'anno siamo nella situazione in effetti che eravamo 2 o 3 mesi fa. Anche i punti di blocco sono gli stessi 3 punti di blocco che avevamo già 3 mesi fa. Infatti sono punti che sono in discussione sin dall'inizio, sin da febbraio, ma sono almeno 3 mesi che è evidente ed è chiaro che sono tutto quello che riguarda la pesca, tutto quello che riguarda il cosiddetto level playing field, o la concorrenza, se vogliamo, tra il Regno Unito e l'Unione, e la governance degli accordi, che sono i punti più importanti, i punti che sembra siano i punti per il quale c'è il blocco, per il quale siamo in questa situazione. È vero che ci sono tanti punti di meno, o forse anche di più rilevanza, però che sono punti che sono rimasti più facili a trovare un accordo. Ma su questi 3 punti non stiamo andando da nessuna parte, o almeno sembra. Nell'ultima puntata abbiamo visto che c'era qualche spunto di ottimismo, c'era qualche idea che magari arriveremo ad un accordo. Devo dire che sentendo i commentators, guardando la posizione, mi sembra che questo ottimismo sia molto diluito, se non sparito. Addirittura ho parlato pochi giorni fa con qualcuno che era molto sul pezzo, che diceva che 2 settimane fa pensava 80% che arrivassimo a un accordo, e ora ha dei grossi dubbi e è arrivato almeno alla parità. Il punto forse più mediatico, più di rilevanza, è che ieri sera si sono incontrati la Presidente della Commissione, Ursula von der Leyen, con Boris Johnson, il primo ministro inglese, britannico. Hanno cenato assieme. Sembra che la cena non è stato super felice. L'unico esito, almeno pubblico, che si vede è che hanno deciso che non era il momento di chiudere, non era il momento di alzarsi dal tavolo e andarsene a casa, era forse il momento di trovare qualche giorno in più. In effetti hanno trovato qualche giorno in più e hanno instaurato un nuovo deadline, e questo deadline sarebbe il domenica. Detto questo, chiaramente abbiamo visto tanti deadlines, abbiamo passato tanti deadlines negli ultimi mesi, perciò credo che dobbiamo prendere questo come un altro deadline. Si spera forse però che questo deadline possa essere, magari anche nel senso negativo, un deadline che potrebbe essere veramente un deadline, che potrebbe dare almeno qualche giorno, qualche settimana, perché le aziende e il mondo del business si possa adeguare per quello che arriverà a fine anno. Come abbiamo ripetuto tante volte durante questi aggiornamenti, cambierà, cioè con o senza accordo, e all'inizio di gennaio ci saranno dei cambiamenti molto forti e bisogna prepararsi per questo. L'unico punto, per essere un po' frivolo, della cena che è stato interessante è che, come sapete, uno dei punti più lottati in questa negoziazione è stata la pesca, e la Presidente della Commissione ha deciso di dare una cena completamente a base pesce, che magari c'era o magari no, come un messaggio forse sublimino. Perciò siamo ancora senza accordo. L'unico punto veramente di positivo, credo, è stato proprio negli ultimi giorni che il governo britannico e la Commissione hanno trovato un accordo sul protocollo per l'Irlanda del Nord. Questo è importantissimo a tantissimi livelli, e questo protocollo praticamente stabilisce le guidelines per la frontiera. La frontiera invisibile, una frontiera soft tra l'Irlanda del Nord e la Repubblica Irlandese, che è un punto molto importante per salvaguardare la risoluzione, se vogliamo, ma essenzialmente la pace che trova l'accordo di Venerdì Santo per l'isola dell'Irlanda. Abbiamo anche qualche notizia su dei provvedimenti che sta mettendo in atto l'Unione per quanto riguarda il trasporto sia aereo che stradale, che aiuterà la continuazione della possibilità di mantenere questa via di trasporto anche se non c'è accordo, e anche all'inizio del 2021. Però anche se si riesce ad arrivare a un accordo, come sappiamo, questo accordo sarà un accordo light, diet, se vogliamo, che non tratterà di servizi, non tratterà di questioni di origine. Ci saranno comunque delle discussioni, delle cose lasciate in aperto, anche persino al discorso della trasmissione dei dati. Perciò continuiamo ad essere in attesa, continuiamo ad aspettare con molta necessità e molta voglia di avere qualche spunto di certezza per andare avanti. Passiamo allora ai nostri ospiti di oggi. Come in passato, se avete delle domande, vi preghiamo di metterli e di scriverli nella Q&A che trovate in basso sul vostro schermo. Per favore non mettere le domande nella chat. Potete usare il chat, non è che voglio mettere delle regole fisse, però è molto più facile per noi per gestire le domande alla fine degli interventi, se sono tutti nella Q&A. Per iniziare passo al mio primo ospite, Bill Cohen. So again, welcome Bill, thank you for being with us today, and as we say in Italy, I'll pass the word to you.
Thank you, Stephen, very much. Good afternoon, everybody, again. So we're here to talk about the people movement implications of Brexit. Of course, everything, as you've just heard and you've seen in the press recently as this morning, everything remains unsettled and uncertain. We're going to look at some key aspects for people and for movement of employees or people generally across border. The current negotiations between the UK and the EU certainly at best seem to be stalled. There are those that are suggesting that we may not get a deal at all. There's a new deadline. I see this morning there's a new deadline set for an agreement on Sunday. But what we're going to do is take a look at the implications as we know now, and have around these key areas for people movement, have a little bit of thought to a no deal or a deal scenario. So first up, we're going to look at the implications in terms of immigration up to the end of this month, and after, so from 1 January. So the 31 December deadline is a key date for individuals. Here in the UK, from 1 January, effectively a points-based system will apply for immigration. Before that, however, there is an opportunity for individuals who are already in the UK to apply for a special status. So it's either settled status or pre-settled status. This is all under what is called the EU settlement scheme. So what are the two differences? Well, key is settled status. So that is available for individuals who, by the 31st of December 2020, so in a few weeks' time, they have at least 5 years continuous residency in the UK. And they can apply for a settled status. That will enable them to continue to live and to work and to gain various benefits and access to health schemes and the National Health Service and so on here in the UK. Continuous residence for this purpose means at least 6 months in any 12-month period over the last 5 years. So that's the settled status. For those that have not got 5 years continuous residency, they can apply for pre-settled status. Again, initial criteria is they must be living in the UK by the 31st of December 2020. And effectively, they can apply for this pre-settled status. And then after a period of 5 years, if they're still here, they can apply for the settled status. Pre-settled status will also give them the right to work here in the UK, to live in the UK, and have access to National Health Service and so on. The deadline for the application of them all, both settled and pre-settled status, is the 30th of June 2021. So in effect, EU citizens in the UK have a continuing right to live and work here until that date, 30th of June 2021. But they must apply for settled or pre-settled status by the 30th of June 2021 in order to avoid the points-based system and so on. UK nationals outside of the UK working and living in EU states will, after the 31st of December, effectively have to look at the local visa requirements, working visa requirements, and so on. So Italy is a very good example for me. Currently, the UK government are advising UK nationals who are living in Italy that they should apply for resident status before the 31st of December. The government website also talks about uncertainty post the 31st of December. And that uncertainty, of course, relates to whether or not there is going to be a deal agreed between the UK and the EU or not. So let's just have a look at that. So you've got that immigration perspective, and as things currently stand, you've got that status in the UK, and then for EU member states, for UK nationals living and working there, they have to look at local visa and residence requirements. So what if there is not a deal? So if a no deal Brexit occurs? Well, we have a transitional deal, as some of you may well be familiar, that applies to the 31st of December. So although the UK formally left at the end of January this year, we have this transitional deal. Now, that transitional deal deals with immigration and social security, which we'll touch upon in a moment. But what if there is a no deal? Well, the transitional agreement is finished. So all individuals in the UK before the 31st of December can apply for settled or pre-settled status. From 1 January, everybody wanting to work in the UK will have to work on the points-based system. For employers, that will mean that they have to gain a sponsorship license in the UK, which can be quite a long, expensive and drawn out process. Once an employer has that sponsorship license for their employees that they want to bring into the UK from EU member states, they can apply for what would typically be a Tier 2 visa. So that's a visa that enables the employee to live and work in the UK. The Tier 2 visa is the most common visa in this sort of scenario. It's an intercompany transfer. So that would be for your assignees coming into the UK and wanting to work in the UK for the UK entity or for the business in the UK. As I say, for UK nationals working in EU member states, they will need to register and apply under the local visa and immigration system for appropriate visas and so on. So what if a deal is struck? Well, we don't know. We don't know the impact on people movement. We don't know the impact on immigration. However, the general consensus is because the transitional arrangement has most definitely included elements that cover immigration and cross-border movement of people for work and living. If a deal is struck, the view is that it will likely contain some elements that are already in the transition agreement. But again, there's a great deal of uncertainty as to whether a deal will be struck, and if a deal is struck, what it will include. There is a view that there may well be an extension. So we either have a no deal, a deal, or actually they haven't quite agreed a deal. So will they extend the transitional arrangement? That's potentially possible. The press here in the UK, there is an element of the press here in the UK that believe that that will happen. That if you look at the history of the negotiations and so on, we have a lot of brinkmanship, we have a lot of deals rushing past deadlines and then a new deadline being set up and so on. So it is possible that that transitional arrangement might be extended so we maintain the status quo during that extended period. So that's the immigration piece. The other piece that I wanted to touch upon is the social security position. It's interesting that tax, particularly personal tax, is not really impacted by Brexit because personal tax, so people moving cross borders to work and so on, and tax residency positions are covered by two things: local tax law in the country, but secondly, treaties. And there are treaties between the UK and EU member states as individual states, not as EU-wide. However, that does not apply for social security. So currently what we have in the UK is an EU-wide or a European Economic Area-wide agreement around social security for employees that are moving across borders to work in different EU states. It's all classed as the posted worker rules. In essence, what that currently means is an employee that is going to remain in employment in their home state, their home country, and move to another EU state to work for a temporary period, and that is classed as initially up to 2 years. They can remain in the home state social security scheme. So an example, a UK national moving to Italy for a period that's not expected to exceed 2 years at the outset can apply for an A1 certificate and remain covered by the UK scheme. Both employer and employee continue to pay UK social security and do not have to pay Italian social security, but are covered by the Italian social security scheme. Now, at the moment, as of 31 December, that all goes away. Again, it is 100% covered by the transitional arrangement, so the same issue around deal or no deal will apply. But there's a great deal of uncertainty as what will happen from 1 January, I beg your pardon. So if there is no deal, then potentially employees and employers could be liable for social security in 2 member states. There is one transitional arrangement which will actually go beyond 31st of December, however, and that is included in the current transitional deal. So any situation which is in place by 31 December will continue during its validity. So if we take my same example, so if we have a UK national working in Italy and they have an A1 certificate that is covering them for 2 years, that will continue, that arrangement will continue until the expiration of the certificate. And that will give coverage for at least the term of that certificate. So that gives some certainty, and for those employees who are currently working across border in EU member states, at least the arrangement that's in place will continue thereafter. We can hope for a deal, and we can hope that there is some European-wide agreement on social security, but again, without a deal, that all disappears from 31st December. So without further ado, I'm going to hand you over to Helen now, and she's going to talk about some of the more HR aspects.
Thank you, Bill. Very interesting. And so now we pass to Helen Chamberlain. Helen, again, welcome, and over to you.
Thanks, Bill, and thanks, Steve. So good afternoon, everyone. So a little bit about what we do, but also a little bit about what we can do to help. So we have 3 main areas that I'm responsible for: global HR advisory, global HR compliance, and compensation and benefits. And I think the movement of people, we've noticed definitely over the last few weeks, it's been very much about COVID, and the last few months has definitely been about COVID and people that are on furlough and different avenues that people can look at. However, moving forward, I think Brexit's definitely now on the radar, and therefore looking at what we do next is absolutely key for everybody. We support on our strategic sides, we support on operational sides, but we also support on actually what are we doing today. And I think for us at the moment, and we sort of joke about we don't know quite what is happening, and I think that is it, absolutely it. We don't know from one day to the next at the moment, and I think everyone will agree. We sit with bated breath on the next news flash of what's going to be. But the areas that I would be responsible for and look after are if you're moving people around the country, or if you have people that are currently on furlough or through the COVID scheme, they're actually working from home in different jurisdictions, then obviously they're the areas that we are also supporting on, because we think we move people to their home country, for example, out of the UK, and they've probably been sat there since March. And it's what do we do with those individuals now, and how do they get back into the UK if they haven't got the particular status that Bill's referred to earlier. So there's lots of aspects regarding that. There's also aspects regarding the actual recruitment of people, and also the situation currently with the COVID and the coronavirus situation is severe in so many industries, especially the hospitality industry, where obviously it's what is going to happen in 2021. And at the moment, it's looking that there are going to definitely be some major changes due to the current climate. So all of that comes under our HR advisory, linked in with the compliance part that we mentioned. And then obviously moving forward, and we look at when we move forward about how things will work and what does 2021 look like? And I think we'd all like a crystal ball at this moment in time to know what that does look like. But trying to move forward and look at it positively, there's lots of different avenues that we're working on in relation to how do we support clients and how do we support businesses moving forward in the new way of working. We don't think we'll be returning back to offices in the very near future anyway. They'll be still working from home. It's whether or not that becomes a permanent fixture. And again, do people still remain in their home countries if they're not a UK citizen, or do they actually want to go and live abroad because they are a UK citizen and that actually works for them? So some people might want to decide to go and live in other countries. So there's lots of different open-ended, I would say, at the moment, of what do we currently want and what do our people want really moving forward. Thanks, Gino.
Thank you, Helen. Ora passiamo a Gino Zapeo, il nostro terzo e ultimo ospite da Vistra. Gino.
Grazie Stephen. Posso parlare in italiano, posso parlare in inglese, ma in sostanza quello che dicevano i colleghi precedentemente ha un'implicazione per poi come si strutturano le aziende per accomodare queste situazioni cross-border, e quindi capire se è necessario a questo punto per le aziende stabilire una presenza in un paese estero. Facciamo, per semplificare l'esempio, Italia e Inghilterra. Se ci sono dipendenti che si sono, a causa del Covid o comunque per altre circostanze, o anche a causa del Brexit, hanno preso la decisione di trasferirsi dall'Inghilterra all'Italia o viceversa, però il loro datore di lavoro non ha una presenza nell'uno o nell'altro paese, si pone la domanda su come formalizzare il rapporto di lavoro e su come poi procedere a stabilire un processo di pagamento che sia legittimamente in compliance, e quindi abbia l'opportunità di operare trattenute, versare i contributi ed essere a tutti gli effetti un rapporto di lavoro che rispetta le regole del paese in cui il dipendente lavora effettivamente, e mantiene poi il datore di lavoro e l'azienda stessa il rispetto delle norme. Quindi ci sono diverse opportunità a seconda se vogliamo, delle circostanze, e quindi quello che bisogna tenere presente è che bisogna considerare tutti gli aspetti, nel senso che tipicamente si guarda l'attività, cioè quello che i dipendenti svolgono quotidianamente per conto del datore di lavoro ha una diretta correlazione con il tipo di struttura che si va a costituire nel paese in cui si opera. E quindi ci sono diverse soluzioni e possiamo vedere, diciamo, side by side, perché così si facilita la comprensione di che cosa si sta parlando. Il primo, se vogliamo, the first solution and the very basic is that the people could consider, that companies could consider, is the representative office. And it does exactly what it says on the tin. It represents the company in the host country, and therefore does not in itself constitute a limited company or constitute a business unit. It is simply there to start exploring market opportunities and developing the market, and developing essentially an interest in the services or products that that particular company can offer to the local market. And the process for a representative office to be established is relatively straightforward in terms of both timing, but also in terms of requirements, minimum investment required. And at the same time, it's also very easy to shut down if things don't work out. So if the situation, for example, that was due to COVID or Brexit, then comes to an end in 6 months or 9 months' time, it can always be shut down. And essentially, all it takes is the communication to the local authorities that that representative office is no longer needed. And of course, it's also limited in terms of activities that are allowed. Typically, they're only allowed to essentially conduct marketing activities, make the products known, make the services known, but are not allowed to engage in any formal trading or sign contracts, for example, or take out office space. Those are activities that best suited for a branch or an entity. And these are the two other options available. So branch is essentially a business unit in a foreign country, doesn't have a legal entity, or it's not a legal entity in its own right. It's still part of another company. And again, it does require some formal registrations, but it's slightly more substantial than a representative office. It does have the need for filings, additional filings, and it almost mirrors in terms of compliance what a limited entity will be expected and required to produce. However, it's still not a limited entity, and by limited I mean limited responsibility. So the legal financial liability is directly exposing the parent company to any kind of risk that is generated in the host country. So something to bear in mind, and that is basically the main fundamental issue and the main fundamental difference between a branch and a limited entity, as well as when closing down, the branch is again not a limited entity, that therefore doesn't require a formal liquidation. So the cost to exit the market is still relatively low, but it's not, again, it needs to be contrast and basically weighed up between the risk that exposes the parent company. So the limited company is really the formal legal entity that allows businesses to operate in country with the full range of allowed activities, but also opportunities, because they can open bank accounts, they can take out office space, they can engage with clients if they want to, and therefore all the typical activities of a business. But most importantly, especially linking with what my colleagues were saying earlier, does also create a substance that usually makes it easier for the company to apply for a sponsorship license and therefore bring in resources from outside of the country, especially in the UK. So if people are considering a long-term or a permanent solution, certainly a limited entity or a branch have a better chance of being successful in applying for a sponsorship license, and therefore provide essentially the way to apply for visas for their workers or employees that want to move to the UK and vice versa. So in essence, these are the options available, and businesses can evaluate what is their priority, their long-term plans, the projected headcount that they wish to establish in a country, and whether it's also a priority to engage with local clients, and whether it's the propensity to risk, essentially, to how much risk they want to take on when they make their investment decisions. So this is, in a nutshell, the presentation that I was going to put forward today, just to get people thinking about what they would like to do in terms of assuring a solution that allows them to continue to trade with or without a deal, and with or without the replacement of an existing arrangement. And therefore, this will future-proof essentially the business plans of companies that wish to operate cross-border. So back to you, Stephen. Thank you.
Grazie mille, Gino. Thank you very much. We have a couple of questions, and I have a couple of questions. What I'll do is I will give everybody time to put in their questions, and maybe I'll send out a few tests myself. So the first question we have is, I think, headed towards Bill, since it picks up something that he talked about. The question is, if the UK is allowing EU citizens until the 30th of June to register, I think that's 30th of June 2021, why is the same not true for UK citizens in the EU? I think, Bill, that's probably it's aimed at you.
Yes, thank you. So the simple reason is the EU settlement scheme only applies to after 31st December. Generally, individuals being allowed to stay in an EU member state. In the UK, there's specific legislation which is around the settled and pre-settled status, which applies that deadline, and it gives that longer period of time. So the simple answer is it's a local government decision under local immigration laws in the UK to provide that additional period of time down to 30th of June.
Thanks, Bill. And I think this one, I'll let you choose whether it's Helen or back to Bill. So the question is, will multinationals sponsor EU residents for all level of roles, or will the cost be too high for entry level?
So I'll take that one. I suspect the cost will be too high for entry level. The points-based system that will apply in the UK from 1 January, there are certain levels and certain restrictions on those different visas that you can get. So the tier 2 visa that I mentioned, which is the most common visa to be applied for once the sponsorship license has been obtained, that's for intercompany transfers. There will be, and non-EU countries, there will be a minimum salary requirement in there, and so I suspect that entry-level salaries will be successful. However, there will be exceptions to that, and there will be exceptions as set by the UK government and the UK immigration authorities. So different types of employee, for want of a better word, will have exemptions to that. I'm thinking particularly of those coming into the UK to work for the National Health Service, for example. So there will be a lot lower bars for those, and particularly maybe for farming industry, that type of business. But they will be exceptions set by the UK authorities. They won't apply from 1 January specifically to EU nationals. They'll apply to any nationals coming into the UK.
Thank you very much. Whilst we're waiting for more questions, I have a question which I'll put to you in Italian and then I'll translate for you. Allora, la mia domanda è legata a una domanda che mi viene chiesta anche a me molto spesso, che è che io sono un'azienda italiana con un contratto di fornitura di un macchinario, di un impianto in Regno Unito, e io fino ad ora mando non solo l'impianto che ho costruito, che vendo, ma mando anche i miei impiegati che montano e installano questo impianto. Questo continuerà ad essere possibile, o dovrò trovarmi, non so, o il manodopera d'Inghilterra o qualche modalità formale per poter mandare i miei impiegati? I'll translate that into English and then you can decide between three of you who's going to answer. So my question is, it's a question I get asked quite often as well. I'm an Italian company. I have a contract to build some piece of equipment, piece of plant or something like that, which I build in Italy for a UK client. So I'm sending it from Italy to the UK. So we won't for this point of my question, don't look at things like import duties and all that kind of stuff. Just keep to the people. Normally, I would send 3, 4, 5 people with my new piece of equipment. They would go to the client, they would install it, test it, service it, commission it, all that kind of stuff. So my question is, will that change, and how does it change if it does?
So again, if forgive me, colleagues, I'll take that one as well. So there's various implications there. There's immigration, tax and social security. Immigration piece, it is most likely that those individuals coming into the UK, in your example, to deliver, set up and so on, there would be some leeway from an immigration perspective for a short period, 30 to 60 days, for example. So if the job can be done in that short period of time, then everything should be fine from that perspective. If it's beyond that sort of period of time, then you would be looking at, from 1 December, sponsorship license, tier 2 visa and so on. Additionally, from a tax perspective, whilst, as I mentioned, tax, Brexit doesn't impact tax so much because of tax treaties between the UK and individual member states. Coming into the UK from a tax perspective, again, there are 2 aspects of tax. One is, does the individual themselves create a tax liability for themselves? And secondly, does the company that employs that individual have a compliance requirement here in the UK for operation of payroll, withholding of tax, and or social security? So the answer to the first is, again, short period of time, less than 60 days in the UK in any one tax year, will typically not create an issue for the individual from a tax perspective. As a very broad statement, and I give this with a little bit of caution, as a very broad statement from a tax perspective, an individual, particularly coming from any EU member state, is likely to be covered by the treaty, and provided they're not in the UK for 183 days in any 12-month period, in excess of 183 days in any 12-month period, they're not going to have a personal tax liability here in the UK. That's on the assumption if they're an employee, they remain employed outside of the UK. So from the individual perspective, under 6 months, under 183 days, not likely to be an issue. From the company perspective, as I mentioned, 60 days, less than 60 days in the UK, then there's no compliance obligation, and the company would not have to operate payroll. Now, interestingly, over 60 days, there is a technical requirement that they may have to operate payroll, or at the very least, they may need to get some information and some documents to UK Inland Revenue or UK HMRC to prove that the individual is paying tax and tax resident outside of the UK. So, I mean, generally speaking, I think for short terms in the UK, certainly less than 60 days, you're going to be fine from an immigration and a tax and an employer compliance perspective. Above that, and I think you really do need to be very careful about the length of time the individuals will spend in the UK.
Great, thank you. Just on that point, because we have a question which goes back towards more of the sort of corporate entity. I just wanted to ask a question before I ask that one. If I am an Italian citizen, or for that matter, a French citizen, or whatever, from the member state, and I am a director of a UK company, does anything change?
Well, let me jump in first. Gina may have something on the corporate governance side, but again, there is a big impact potentially here, and it's from a tax and a social security perspective. From the tax perspective, if an individual is a director of a UK company and spends time working in the UK, then the income related to that time in the UK is taxable in the UK, irrespective of the individual's personal tax residency position. So let's take the example: an Italian is a director of a UK company, comes into the UK for perhaps board meetings and to carry out director duties. A portion of that individual's income will be taxable in the UK, irrespective of the fact that that individual would presumably be Italian tax resident and not UK tax resident. So there's a big impact from a tax perspective, most definitely. The social security perspective, the individual, there's a separate piece of legislation outside of the posted workers legislation that I was talking about. There's a specific piece here in the UK that enables an overseas resident director to come into the UK for defined duties and not expose that individual to a social security charge. And that typically is if they're coming in for board meetings and for the associated work around board meetings. So there's a specific exemption there that would prevent a social security charge. Outside of that, if the duties extend beyond those board meetings, that type of thing, then you're looking at that whole regime that I talked about earlier as to whether or not there is a deal in place or no deal in place. And if no deal in place, you could end up with a dual social security liability that would coincide, I suspect, with the tax liability that I talked of. So being a director of a UK company immediately will have tax and social security considerations.
Thank you very much. I pass now to Gino, who might have something to say on that, and warn him that there are at least 3 or 4 questions that I'm going to fire at him in relation to subsidiaries and branches and things.
Sure.
So do you want to add anything to Bill before we move on?
Essentially, that if you are director of a UK company, then you are responsible for that company, and therefore there are specific duties and responsibilities, but also if you want some ways to limit the exposure, because it can be if in cases of negligence, for example, as a lawyer, you will know better than I do that in case of negligence, obviously that exposure cannot be completely eliminated, but there are ways to limit the personal responsibility in terms of financial burden, but certainly not in terms of duty of care. And therefore the duty of care is something that people need to be aware, and it will be under UK law. So they need to have an understanding of their roles and responsibilities and duty of care.
Thank you. Linked to that, there's a couple of questions. So I'll just give you the scenario and then you can comment. So I'm Italian. I want to go and live in the UK. We're talking after the 31st of December this year. Can I set up a UK limited, be it sole director, sole shareholder maybe, and effectively sponsor myself to go and live in the UK, even if it's, let's say, in February of next year, regardless of whatever may or may not be in any kind of free trade agreement?
So that's a very interesting question, Stephen. So in terms of, can I set up a company in the UK as a non-resident? Yes. I can be sole director? Yes. Can I be sole shareholder? Yes, although there will be a kind of boundary, and we'll have to look at the substance, because in cases of, again, negligence or pushing the boundaries too far, the veil in incorporation could be lifted, and therefore that person will no longer be awarded the limited liability, but will be fully responsible with unlimited liability. So there is something to be considered. So it's always best to make sure that the company is a true company, and therefore not, if you want, a cover for an individual. But and to answer your question in can I sponsor myself? Now, we were talking about this, Bill, earlier on actually, and that's probably going to be a challenge, because for, yes, I'll hand over to Bill to explain why.
Thanks, Gino. So, yes, so the sponsorship scheme, which will apply across the EU from 1 January, the UK entity, as Gino has described, can apply for a sponsorship license, most definitely. There's a very important role in applying for that sponsorship license, and that's called the Authorizing Officer. Now, the Authorizing Officer does not have to be UK resident, but the Authorizing Officer does have to spend the majority of their time in the UK. So in the example given, technically it's possible. So technically, an Italian individual could set up a UK company, as Gino's described, become the director of that company and apply for a sponsorship license. However, as I say, part of the application for that sponsorship license is appointing an authorizing officer. That individual could be the authorizing officer, but in order to carry out that role, they would have to spend the majority of their time in the UK. So exactly as Gino says, it would be quite difficult unless the individual themselves was wanting to come to the UK and spend the majority of their time in the UK. There is nothing technically that stops that authorizing officer being an individual that, for example, would have a tier 2 visa, but it's quite difficult to achieve.
Great, thank you. Another question. As regards Italian subsidiaries or branches of UK companies and vice versa, would there be different compliance requirements with regards to GDPR or the new UK equivalent of GDPR from the 1st of January 2021?
Yes, there will be the simple answer. And it's all to do with the fact that at the moment, the UK is implementing the EU GDPR rules and regulations, and the UK government has stated that they will want to incorporate those rules into UK law. However, that's not quite happened yet, and how they're going to mirror word for word the EU rules going forward is still not certain. And for this reason, the EU has not recognised equivalence yet to those GDPR rules, and for that reason, the transfer of data from the EU to the UK has to be covered by the standard clauses and special standard clauses in the transfer of data agreements. However, the transfer of data from the UK to the EU, that's different because the EU applies the GDPR regulations, and therefore that's still covered by the GDPR EU rules. So companies will have to look at the flow of data, in which direction it goes. And therefore, if they have a UK parent company transferring data to, for example, Italian subsidiaries, that's fine. Vice versa, they will have to draft appropriate standard clauses.
Thanks, Gino. Another question. Do you think that in the future, individual EU countries will be competing with one another to attract UK businesses by offering them different types of incentives?
Yeah, that's a very good question, Stephen, and one that I've been asked more and more often, actually, especially around R&D. And of course, the link to the R&D, there's also the green budget and the green economy, which drives that research and development spend and investment. And I think more and more countries will try to attract the so-called unicorns and high-tech companies that are at the forefront of R&D, and therefore will be the next future generation success story. And for this reason, they're still investing in R&D incentives. The UK, for one, has got a generous R&D scheme, but again, is on the assumption that there is substance in the country. So there's always a but, and there's always a cost to pay when considering these investment decisions. The access is given to businesses that are real businesses and are conducting businesses on the soil of the countries. So circumstances will need to be assessed, and it's not a simple, if you want, umbrella that covers everything. Each project will have to be considered carefully. Therefore, each submission will have to be evaluated, and it's not guaranteed that it will be successful.
Thank you. And then I think, given the timing, last question. I have a limited consulting company in the UK, of which I'm sole shareholder. I'm moving to Italy and have residence in Italy. If I work for client companies in Italy, the invoices will be generated by the UK company. Is this okay? And do I pay tax in both countries and then get credits through the double tax treaty or whatever? And how do I make sure I'm not paying tax in both countries on the same thing?
So this is, again, another typical question. So this is the concept of permanent establishment, and where the trade is physically conducted on which soil, on which country. And by conducting a business, the accepted principle is that it's the final agreement. Where does the final agreement is reached between buyer and seller? So if the negotiations are determined and then concluded in Italy, that contract and related revenue is taxable in Italy. However, because it's generated from a UK parent, and we'll probably discuss about what to do in terms of being compliant in Italy, but because the parent company, the ultimate parent company is the UK business, some of that revenue and income will have to be reflected in the tax returns of the UK entity as well. There are double tax treaties that would avoid the double tax on the assumption that there is obviously a tax return being filed in both countries. And of course, this leads me on to the other point that I was going to make, that if the business does not have a presence or an establishment in Italy, they will have to think about how they go about establishing a branch or a limited company in Italy to be compliant.
Thank you. Speaking of branches, one of the things that I hear a lot is about the difficulties of rapporto with the agencies, specifically in things like the Dogana, things like tax authorities. And as I understand it, but I'm no expert, you have to be established, at least as far as the UK is concerned, you have to have an establishment in the UK in order to do that. Since we've talked about subsidiaries and about branches, I take it for granted that a subsidiary is clearly established, but would a branch be sufficient in terms of the necessity for establishment to be able to give you access to your, I don't know, your VAT declarations, your tax declarations on your imports, or do you actually have to have a subsidiary?
No, the branch, in terms of scope of activities and scope of engagement, can act as almost as equivalent to a limited company. The only difference is that the limited responsibility is open to the parent company, and therefore it's not entirely insulated from any kind of local, legal or financial exposure. The one that does not allow you to fully represent is the representative office, because that is simply sales and marketing. It's not actually physically conducting any form of trade or representation. Now, in terms of, you raise an interesting point, Stephen, because there is an awful lot of talk now about not just tax implications, but practical considerations around the health and safety, for example, or the certification. The pharmaceutical companies will have to look at, for example, getting a special UK registration going forward. And so that the equivalence of the CE logo or the EU-wide pharmaceutical license will have to be considered carefully by companies. So all of that compliance can be put in place using representatives, specialist representatives, that will allow to essentially conduct the business with the authorities, but they wouldn't necessarily be sufficient in certain circumstances, and therefore, yes, as a minimum, a branch will have to be established in those circumstances.
Thank you very much. Bene, allora abbiamo esaurito il nostro tempo e a questo punto chiudiamo. I would like, I've just announced that I'm closing the session, and therefore would very much like to thank Helen, Bill, and Gino for their contributions and interesting comments and answers to our questions today. Vorrei anche ringraziare i nostri sponsor di tutta la serie di queste puntate, UPS, KPMG, Studio Legale Semi, and of course Vistra. E con riguardo alla sessione di oggi vorrei ringraziare anche l'Associazione Italiana per la Direzione del Personale per il loro sostegno di questo evento. Siamo arrivati alla fine della nostra serie di puntate. Purtroppo non vi abbiamo potuto dare certezza per il futuro, che era quello che si aspettava proprio quando ci siamo messi a programmare questa serie di puntate. Spero comunque che vi abbiamo dato dell'informazione utile, pertinente e che vi aiuterà a prepararvi per almeno il futuro prossimo, se non il futuro un po' più lontano. Come ho preannunciato, forse un po' prematuro all'inizio di questa puntata, stiamo già preparando la nostra, cosa faremmo con riguardo all'uscita definitivo del Regno Unito dell'Unione Europea e il nuovo rapporto che dovrà essere installato con o senza un accordo di libero scambio, con o senza l'intervento delle regole del WTO o magari anche qualcosa che ad oggi non possiamo neanche immaginare che sarà il nostro futuro. Mi rimane solo di ringraziarvi per averci seguito, di essere stato con noi durante queste 5 puntate e di augurarvi una felicissima Happy Christmas e un futuro prospero nel 2021 e per il futuro. Grazie, arrivederci.
Grazie.